All rise. Veuillez vous lever. Please be seated.
The appeals chamber now will hear the rest of the defense reply, and you have 36 minutes left of your reply time. Defense counsel.
I'm grateful, Madam Presiding Judge. Ground 4. My learned friend for the prosecution argued that the tribunal does have jurisdiction over the crime of terror. She invites the chamber to find this on the basis of Garlich and the fact that it was foreseeable to Mr. Mladić that his conduct would lead to a conviction on terror. I will take these points in turn. The prosecution rely on the Garlich decision and the fact that this was followed by subsequent cases to argue that the chamber can be satisfied that the criminalisation of terror formed part of customary international law. My learned friend did not engage with the fact that there is a lack of state practice as identified in the appellant submissions. Rather, she stated that the appellant, quote, ignores that the Garlich Appeals Chamber did not only rely on national laws, end quote. Transcript, page 107, lines 23 to 25. In support of this, she cited a reference to terror in the 1919 report on the Commission of Responsibilities, quoted in paragraph 93 of the Garlich Appeal Judgment. When the quotes relied on by Garlich are placed in their proper context, it is clear that the Commission was making broad statements without coining legal definitions. Further, it is far from clear whether the reference to, quote, systematic terrorism, close quote, is conceptualized in a manner corresponding to Article 51.2 of Additional Protocol 1 or Article 13.2 of Additional Protocol 2. And in this regard, I commend Judge Schomburg's dissent to the Chamber at paragraph 14. Importantly, of the states in the Commission, the Garlich Appeals Chamber did not point to one that had criminalised terror in its domestic legislation, thus undermining the assertion that the Commission report can in some way be taken as evidence of either state practice or opinio juris. With regards to state practice, there was no penalisation of the terrorisation against the civilian population in either the Nuremberg or the Tokyo Charters or the Control Council Law Number 10 on the punishment of persons guilty of war crimes, crimes against peace and against humanity in Germany. The appellant submits the prosecution has failed to undermine the appellant's submissions about the absence of extensive and virtually uniform state practice to show beyond any doubt that the criminalisation of terror was part of customary international law at the time of the indictment. Further, the reliance on the facts that others have followed the Garlich Appeals Chamber decision does not remedy its defective legal reasoning. In fact, it gives further impetus to review the decision to correct the wrong turn that the law has taken as a result of Garlich. The appellant maintains that there are cogent reasons to depart from the Garlich Appeals Chamber's decision. Foreseeability. My learned friend raised the issue of foreseeability. However, she elides the appellant's submissions in this regard. It is clear from the appeal brief that the submissions on the fact that a custom criminalising terror did not exist are distinct from those made about foreseeability. The issue of foreseeability is considered at paragraphs 350 to 372 of the appeal brief and paragraph 70 to 71 of the reply. If a custom is found not to exist, then the question of foreseeability becomes moot. The two must be considered separately. In response to the prosecution's submissions and foreseeability, as they fail to raise any new arguments orally, the appellant recalls and relies on the detailed written submissions in the appeal brief and reply. The appellant therefore invites the trial chamber to reverse the conviction on ground 9. Count 9. Turning finally to ground 9. My learned friend's submissions today are a rehearsal of the prosecution's written response. As no new points are raised, and the appellant has replied to these in the reply brief at paragraphs 128 to 135, I will not address the chamber on this any further. The appellant reiterates and recalls its submissions made at paragraphs 921 to 958 of the appeal brief. The appellant submits that the imposition of a life sentence should be reversed for the reasons set out. To conclude Mr. Mladić's appeal, we make the following remarks. The pursuit of a prosecution should never come at the expense of the basic principles of the rule of law. The application of the black letter of the law ensures that emotions and a desire to right socio-historical wrongs do not determine judicial decisions. The appellant submits that the deferential standard of review does not require Your Honours to bend to the trial chamber's findings. The burden on appeal of demonstrating errors of law and fact has been discharged by the appellant. The errors have been clearly identified in the appeal brief, and the prosecution has failed to undermine these. The appeal is meritorious. For the reasons set out in the appeal brief, the appellant invites the chamber to reverse the convictions entered by the trial chamber on counts 2 to 11 of the indictment and enter not guilty verdicts on all counts. Madam Presiding Judge, Your Honours, that concludes the appeal on behalf of Mr. Mladić.
I thank my colleague, and Your Honor, just one correction for the record. In my haste, and I apologize to the translators and to the court reporter, temporary transcript page 44, line 22, when I said P1145, page 45249, I meant to say P1445, page 45249. And with that correction, that is all. Thank you.
Thank you. This concludes the submission in relation to Mr. Mladić's appeal. The appeals chamber will now hear the prosecution appeal. Counsel for the prosecution, you have 30 minutes.
Madam Presiding Judge, I have a question for the prosecution before they present their appeal. And I needed one clarification from the defense side. So if you allow me, I'll put my questions. Thank you.
Judge Nahamia?
The clarification I'm seeking from the defense is there is an allegation about the trial chamber having made an error in finding that the indictment details sufficient material facts, such as the identity of victims, dates, locations, and perpetrators for each incident, whether enumerated by schedule or not. I would like Ms. Bagot to give me clearly just 2 instances of this error. What exactly is the error? Then secondly, did you bring this matter to the trial chamber on scheduled incidents? If you did the chamber give you any directions on what to do concerning the scheduled incidences? For the prosecution, the appeals chamber in the Karadzic case upheld the trial chamber's findings that there was no genocide in certain municipalities in Bosnia and Herzegovina in 1992. What are the reasons for this appeal, our appeals chamber, to deviate from this determination? Thank you.
Shall we start with, okay, go ahead.
The defense can give me their response, and then the prosecution, before they start, as they give their part, they can also give me an answer to that. Thank you.
Your Honour, turning to the first question, which was in relation to 2 clear incidents, the first of which I would direct Your Honour to cruel and inhumane treatment incident EIII. Your Honour, please can I check my notes before I respond? Sorry, I've written something down wrong, and perhaps it would assist given the nature of the question. Please can I ask, I appreciate that my learned friend is ready to make her appeal, if I could respond to Your Honour's question at the close of that.
All right.
I'm grateful.
Yeah.
Madam Judge Nahamia, in the Karadzic case, of course, there was different evidence and different findings of fact by the trial chamber. The key difference in the conclusion, there are 2 key differences in the conclusion of the Karadzic chamber on the facts of that case. The first difference was that they found a different formulation of the joint criminal enterprise and the purpose of that joint criminal enterprise and the crimes that formed part of that joint criminal enterprise with regard to Karadzic's involvement. So there was a different formulation where the JCE, the means to achieve the JCE, were found to be JCE 3 crimes. So that's the first distinction. And the second key distinction is that in that case, the trial chamber did not find, on the facts of that case, that any of the principal perpetrators had destructive intent. It did not find that the principal perpetrators had the intent to destroy the Bosnian Muslim community in part. So we have 2 key factual differences in the underlying factual findings in that case. And just to recall, Your Honors, that in this case, all of the crimes that were committed in the municipalities, and by that I mean murder, extermination, persecution, deportation, and forcible transfer. All of that was part of the means that was being used to achieve the joint criminal enterprise purpose of claiming the Serb claimed territory and expelling the rest of the population from that territory. So that was all inside the JCE-1. And in this case, the trial chamber found, on the facts of this case, that the principal perpetrators, the local perpetrators who were committing the crimes in those places, that they had intent to destroy the Bosnian Muslim population in those parts.
And the areas, the municipalities in that case, do they correspond to the municipalities in this case? Where they found there was no genocide? Do they? Exactly.
Thank you, Judge. Some are the same municipalities. So Prijedor, for example, is in both cases, but they are not identical.
Are you ready to give me your answer?
Yes, Your Honour, I'm grateful for the time. As set out in our written submissions and also orally, the appellant's submissions do not relate to the fact that the indictment is defective per se. The issue in this case is the fact that the trial chamber, of its own volition, entered convictions on what were mere accusations. They were not incidents listed in the schedule or were unscheduled incidents. Two examples of this that I would point Your Honour to is cruel and inhumane treatment incident JII. If Your Honour considers the 65-ter witness list, within a single paragraph referring to a scheduled incident, the second sentence refers to something else. That incident which is in the first paragraph, scheduled, the second sentence relates to another accusation, and it was that accusation that the trial chamber entered a finding on as an unnamed, unscheduled incident. The same error occurs in shelling incident D, which is the 14th of May 1992. If Your Honour considers the 65-ter witness list, again, the same issue arises. What occurs is that within the narrative of the witness's evidence, at the top it gives an indication of what they're being called to give evidence about. There is an accusation made. However, that accusation is not specified as either a scheduled or unscheduled incident. Therefore, the appellant submits that falls into the third category of unnamed, unscheduled incidents. And therefore, by entering a conviction on that and holding Mr. Mladić responsible, the trial chamber fell into discernible error.
Judge,
I can't hear anything.
I've got the answers, so they may proceed. Thank you.
The appeals chamber will now hear the prosecution's appeal. Prosecution, you may proceed.
Thank you, Madam Presiding Judge. Today, Your Honors, we ask you to take the trial chamber's genocide findings to their logical conclusion. But for critical legal and factual errors in assessing genocidal intent, the trial chamber would have convicted Mladić of genocide in the Count 1 municipalities. But the trial chamber erred in finding that the parts of the group targeted for destruction were not substantial enough to be counted as genocide. And when it came to assessing Mladić's intent, the trial chamber erred in applying a stricter legal test for leadership figures. Had the chamber not erred, the inescapable conclusion is that Mladić is guilty of genocide, not only in Srebrenica, but also in the Count 1 municipalities, in Prijedor, in Sanski Most, in Kotor Varoš, in Foča, and in Vlasenica. Yesterday, I gave you a brief overview of the crimes that were committed in these municipalities. And today, I will focus on two errors in the trial chamber's analysis. I will first address the errors concerning the heightened standard for leadership intent, which is ground 2 of the prosecution's appeal. And then I will turn to the error in the chamber's assessment of the size or substantiality of the targeted group, the targeted parts of the group, both in relation to the error set out in ground 1 and to remedy. Let me begin with the erroneous heightened legal standard for leaders. The chamber incorrectly held that in the case of leadership figures, the legal test for genocidal intent is stricter. This is a clear error of law. And I say this because when the trial chamber assessed the genocidal intent of the local perpetrators, it correctly looked at the totality of the evidence. It analyzed the circumstances of the crimes to conclude that the local perpetrators had the intent to destroy, in part, the Bosnian Muslim group as such. But when it came to Mladić and the other leaders of the JCE, the trial chamber held that the test is different. For Mladić and his fellow JCE members, the chamber held that circumstantial evidence is legally insufficient to establish the mens rea. And let me take you to these paragraphs of the judgment. Let me first refer you to paragraph 3440, where the trial chamber set out the legal test for intent in relation to the local perpetrators. And rather than put up a slide, I'm going to read it out. In relevant part, paragraph 3440 says, in relation to assessing the specific intent of the physical perpetrators, the trial chamber recalls that where direct evidence of specific intent is absent, the specific intent may be inferred from the surrounding facts and circumstances. And the chamber explains at paragraph 3457 that the surrounding facts and circumstances include the systemic targeting of the victims on account of their membership in a group, as well as the repetition, the pattern, the scale of the atrocities, and the perpetration of other culpable acts against that group. And with regard to the lower level perpetrators, the trial chamber was convinced by the evidence in this case that they intended to destroy parts of the Bosnian Muslim group in the Count 1 municipalities. Now I'd ask your honors to compare this approach with paragraph 4236, where the chamber explains how the law or the approach is different for the leadership. In the paragraph just before this, the trial chamber finds that the leader's statements and speeches were not unambiguous indicators of intent. Then it says at paragraph 4236, quote, an inference that the Bosnian Serb leadership sought to destroy the protected groups in the Count 1 municipalities through the use of a number of physical perpetrators as tools requires more. In the absence of other evidence which would unambiguously support a finding of genocidal intent, drawing an inference on the basis of prohibited acts of physical perpetrators alone is insufficient. In other words, Your Honors, while inferences from the circumstantial evidence about the pattern of crimes may be drawn for the local perpetrators, this same evidence is insufficient for the leadership. For the leaders, the Chamber explicitly says that it requires more. And this is a categorical statement of the law. The Chamber does not say, in light of these facts in this case, no inference is available. It states the law incorrectly when it says drawing an inference on the basis of prohibited acts of physical perpetrators alone is insufficient. That this is a stricter legal test is also clear from the Chamber's discussion of the JCE members' statements and speeches in paragraph 4235. The Chamber looks at these statements without connecting them to the JCE members' direct involvement in the pattern of violent and discriminatory crimes against the targeted group. And this legal holding, this stricter leadership test, is contrary to nearly 2 decades of jurisprudence on genocide from the ICTR and ICTY. As the Rutaganda Appeals Chamber persuasively explained at paragraph 525 of their judgment, unambiguous evidence of intent is rare, including in genocide cases. And the quote from that case is, explicit manifestations of criminal intent are often rare in the context of criminal trials. In the absence of explicit, direct proof, the dolus specialis may therefore be inferred from the relevant facts and circumstances. And this, Your Honors, was precisely the test that the Chamber correctly applied to the local perpetrators. And it erred when it applied a different and higher test to Mladić and the leadership. No rationale can be found in the trial judgment for treating the JCE members differently from the local perpetrators. It is not that the JCE members were more distant from the crimes, because the local perpetrators who were found to have intent to destroy included a number of mid-ranking officers, some of whom were just a rung or two below Mladić. And it cannot be that the local perpetrators were committing crimes directly while the leaders were indirect perpetrators, because the local perpetrators who had the intent also included some officials who were not found to have physically committed any of the crimes themselves. And this is why we refer to them as local perpetrators and not physical perpetrators. The trial chamber offers no explanation for the difference in its approach. Your Honors, the effect of the chamber's legal error is that it will only be possible to convict leadership accused in those rare situations where they unambiguously state their genocidal intent. Because according to this trial chamber, without this other unambiguous evidence, the entire pattern of crimes that a leader unleashes on a population is legally insufficient to prove genocidal intent. And this cannot be correct. If nothing else, appellate intervention is required so that future courts are not led into this same error. Your Honors, if the chamber had applied the correct law, there is only one reasonable conclusion that it could have reached. Mladić and his fellow JCE members intended to destroy the Bosnian Muslim community in the Count 1 municipalities. The trial chamber found that Mladić and the other JCE members used the local perpetrators as tools to commit the underlying acts of genocide on a discriminatory basis against Bosnian Muslims. And based on the circumstances of those crimes, crimes that were controlled by Mladić and his fellow JCE members, the majority concluded that the local perpetrators intended to physically destroy the protected group in each of the 5 municipalities. The trial chamber considered the intensity of the attacks on the Bosnian Muslim communities over a short period of time, the thousands of murders of Bosnian Muslims executed in their homes, slaughtered by the dozen or hundreds when the Bosnian Serb forces attacked Muslim villages, the massacres at detention facilities, and prisoners killed by starvation and beating and lack of medical care. And the chamber also considered the serious bodily and mental harm that further contributed to the destruction of the protected group. The tortures and the beatings, the rapes and other brutal sexual violence. And for the survivors, the trial chamber found that the harm had a long-lasting and devastating physical and mental impact that gravely affected their ability to lead constructive lives. Paragraph 3451. And it properly considered the scale of other atrocities committed against group members, finding at paragraph 3457 that it was vast. The forced displacements, the persecutions, the destructions of mosques and Muslim property, which served to erase every trace of the Bosnian Muslim groups in these locations. Your Honors, those very crimes are Mladić's crimes. They are the JCE's crimes. Almost all of the named local perpetrators and units were directly under Mladić's command and control, and the others were under the control of the other members of the JCE. The trial chamber found that Mladić and the other JCE members used the local perpetrators to commit these underlying crimes, labeled, of course, as war crimes and crimes against humanity, in order to further the common criminal purpose of ethnic separation, by whatever means. And these same criminal acts were also the actus reus of genocide. The trial chamber found that Mladić's contribution to their commission was instrumental. That without Mladić, these crimes would not have been committed as they were. Paragraph 4612. And recall that the way that these crimes were committed was precisely the reason why the trial chamber found that the local perpetrators, Mladić's tools, had the intent to destroy. Your Honors, if the circumstances of the crimes prove the tools' intent, how can they not also prove Mladić's intent? Especially since the evidence against Mladić is much stronger than the case against the local perpetrators. Mladić is guilty of the larger pattern of crimes in all of the Count 1 municipalities, all at the same time. And all of these acts fell within the joint criminal enterprise's common goal of ethnic separation by whatever means. Destroying Bosnian Muslim communities not only clears the unwanted from that location, it also serves as a potent threat in support of ethnic separation elsewhere. And especially since Mladić and the other JCE members made statements further evidencing their genocidal intent. Take, for example, the speeches that the trial chamber found were inflammatory, caused fear, and incited ethnic hatred at paragraph 4235. The derogatory language in the media where Mladić vilified Muslims as the, quote, worst scum. And Mladić's propaganda efforts, drawing on historical animosities, encouraging crimes against Bosnian Muslims in existential terms, warning his people that if we do not eliminate them, they will again seek to commit genocide against us. And I would refer you, for example, to paragraph 4499 of the judgment. Mladić's statements are all the more striking in light of his concern about hiding the crimes from international scrutiny. It was Mladić who cautioned on the day he took command of the VRS that the plan had to be guarded as their, quote, deepest secret. Paragraph 3704. And in January 1994, addressing the Assembly 1 year after the destructive campaign in the municipalities, Mladić was explicit. He explained, quote, "My concern is not that they will create the state. My concern is to have them vanish completely." Paragraph 4629. This statement is an unambiguous and explicit manifestation of genocidal intent, especially when you look at it in the context of the Chamber's other factual findings. That Mladić sought to establish an ethnically pure Serbian state by whatever means, along with other JCE members who repeatedly threatened extreme violence to achieve their shared ethnic separation objectives, including by repeatedly threatening Bosnian Muslims with disappearance and extinction. That Mladić intended, oversaw, and was instrumental to a violent campaign of ethnically based persecution of Bosnian Muslims to force them out of Serb-claimed territory. That his subordinates committed genocidal acts over and over again, crimes that the trial chamber found Mladić contributed to, intended, and was criminally responsible for. And remember, Your Honors, that his call for Muslims to vanish completely was made after he had been repeatedly warned by the United Nations General Assembly to stop ethnic cleansing in the municipalities, stating in unequivocal terms that this ethnic cleansing was, quote, a form of genocide, end quote. And I would refer your honors to trial judgment paragraph 4633 and to exhibits P2045 and 46. In its proper context, it is difficult to imagine a more unambiguous expression of genocidal intent than Mladić's statement, "My concern is to have them vanish completely." Your honors, when all the evidence is weighed together, when his words are assessed together with his deeds, as the law says it must be, when the evidence is weighed as a whole, there is only one reasonable conclusion left, that Mladić intended to physically destroy the Bosnian Muslim communities in all of the Count 1 municipalities. And this brings me to my the final section of my submissions concerning substantiality. This is the only consideration that stood in the way of the Chamber's finding that genocide was committed by the local perpetrators. The Chamber found that the local perpetrators intended to destroy the Bosnian Muslim group as such in the 5 Count 1 municipalities, but then found that the targeted parts of the group were too small. This was an error of fact. No reasonable trier of fact could have reached this conclusion. Your honors, this is the first and only time that any international court has found that perpetrators had the intent to destroy a part of the group as such, but then stopped short of convicting for genocide on substantiality alone. In ground 1 of our appeals brief, we provide detailed arguments as to why each of the targeted communities meets each of the factors in the legal test for substantiality. We also address this in the remedy section of our brief. Today, I'd like to focus on the purpose of the substantiality requirement, because this is not an explicit requirement for genocide or genocidal intent in either the convention or the ICTY statute. But it has been read into the definition. If only a part of the group is targeted for destruction, it must be a substantial part to be considered genocide. The concern was to ensure that the label of genocide is not applied to crimes that are too small. As the Appeals Chamber in Krstić put it, this requirement guards against the term genocide being imposed, quote, lightly, paragraph 37. But the notion of a substantial part has always allowed for crimes of limited geographic scope. And this is because genocide is not limited to crimes on the horrific scale of the Holocaust or the Rwandan genocide. The convention's framers emphasized that legally, the actus reus includes more than mass killing, and the specific intent requirement explicitly includes the intention to destroy the group, not just in whole, but also in part. And this is why the case law has always recognized that genocide could be committed in a single municipality. And I would refer you, for example, to the 1995 Nikolic Rule 61 decision and the Jelicic appeals judgment, and to the many cases finding the crime of genocide in the single municipality of Srebrenica. And when considering a single municipality involving a part of the group, the court must determine whether the part is substantial. According to the leading case, the Krstić appeals judgment, quote, the numeric size of the targeted part of the group is the necessary and important starting point, though not in all cases the ending point of the inquiry, paragraph 12. Krstić stands for the proposition that in some cases, the sheer numbers are enough to show substantiality. Other factors may include the part's relative size, its prominence, the area of the perpetrator's activity and control. And the appeals chamber emphasizes that these are neither exhaustive nor dispositive. And recall that substantiality is only about intention. It is not about how many group members are actually harmed by the conduct. This is critical. The evaluation of substantiality is not about how many people were harmed by the genocidal acts in each place. The question is, did the destructive intent extend to a sufficiently large part of the group or a sufficiently important part of the group to warrant the label genocide? Your Honors, in this case, the numeric size of the targeted group already meets the substantiality requirement. In all Count 1 municipalities, the perpetrators targeted communities of tens of thousands of people. The smallest, Cotravaros, had 11,000 group members. The largest, Priador, had nearly 50,000. These are not insignificant parts of the group. They are not so small that this would be applying the term lightly. Targeting tens of thousands of group members is in itself substantial. But Mladić wasn't involved in just one municipality. His subordinates and other JCE tools were committing crimes with destructive intent across 5 municipalities. And the chamber found that Colonel Basara, one of Mladić's VRS subordinates, targeted close to 80,000 group members across 2 municipalities, paragraph 3513 and 3524. And in total, across all 5 municipalities, they targeted over 128,000 men, women, and children solely because of their group identity. By any measure, this is not a small criminal intention. It is a massive one, and it falls squarely within the definition of genocide on the numbers alone. And the additional factors only further support this conclusion, as we've set out in ground 1 of our appeals brief. The trial chamber found that the pattern of crimes committed in the municipalities was more than crimes committed against individuals. It was not only persecution targeting individuals because of their ethnic characteristics. This pattern of crimes targeted the very existence of the Bosnian Muslim group as such. And recognizing this would not be applying the term lightly. Your Honors, to conclude, the appeals chamber in Krstić warns at paragraph 37 that where the requirements are met, as they are in this case, quote, the law must not shy away from referring to the crime committed by its proper name. And Your Honors, here that is genocide. And it is for these reasons, and all the reasons set out in our briefs, that the prosecution asks you to correct the trial chamber's errors and enter a conviction on count 1, genocide. Thank you.
Thank you very much, Madam Prosecutor. We now take a break and resume to hear the defense response. We now adjourn for 40 minutes and resume to hear the defense response.
All rise. Huye bolewe.